Welcome back to Canadian Justice, where we're discussing an emerging legal theory called common good constitutionalism. Kerry, in the last segment, you were describing notions of universal morality that are a part of this theory. I just wanted to give you an opportunity to finish up your point there.
Yeah, absolutely. I was just making the point that the classical natural law tradition or common good constitutionalism isn't incompatible with freedom. It's not the case that it has absolutely no regard for freedom, but rather it might simply understand freedom in a way that's different from libertarian infused notions of freedom, which tend to treat it as pure license. On the common good constitutionalist view, freedom is more akin to a kind of ordered liberty, that there needs to be both constraints and freedoms within the boundaries of those constraints in order for the common good and human flourishing to occur in a political community.
Now, Xavier, let's not beat around the bush. Common good constitutionalism has been described as controversial. What is so controversial about this, and what is your take on the controversy?
So that's a funny question to ask me because, of course, in my view, there is absolutely nothing controversial about common good constitutionalism. But if you look at if you look at the different interpretations or people with different views, I people may be familiar with the notion of formalism, and in legal interpretation, the notion of formalism means that the form of the law will dictate the way we understand its meaning. And so there are people like originalism, we mentioned originalism at the beginning, that we think that we need to strictly stick to the text that is being enacted, and that the text is the absolute instrument and absolute source of law, and from which we will derive meaning. Now, if you have this view, then of course the notion of underlying principles of morality will freak you out. And so I think for those people, they see these new waves, new scholars, new theories of natural law coming up, and they're realizing that this goes beyond the text, or even I would say it doesn't go beyond the text, but it precedes the text. And so that is incompatible with their view. Now, on the other end of the spectrum, you have progressives, usually that will oppose the same things as they oppose to originalism, being that they dislike the results, the outcomes, or the reasons that are provided by the courts, and they dislike those reasons. And why do they dislike the reasons, and why is this important? Well, it's because there's a lot of people who believe in living constitutionalism that are really results oriented. For them, what matters is that the law achieves certain ends, certain results. And when they look at common good constitutionalism, they're worried that these results will be too conservatives and not going their way.
Now, I want to put one of the other criticisms to you, or perhaps it's not a criticism, but the origins of common good constitutionalism, they do have origins in a Catholic moral framework. And I think that for perhaps progressive, that might be part of the objection. What can you tell us about those origins and how that intersects with, the question earlier about a universal moral framework that would be applicable in a diverse, liberal democratic society that may not have at its base Catholic morality?
Right. So I think this criticism is going a little bit too fast and maybe jumping the gun. Just because I'm not sure common good constitutionalism really originates from a Catholic moral framework, so to speak. Aristotle is called the father of the common good, and he's the one who formulated the notion in the first place.
And as far as I know, Aristotle wasn't Catholic.
He wasn't. He was Greek. And then the Roman understood the nature of law as a reasoned action, as we've been discussing as well. So you have that in Roman law. And then, of course, Aquinas, one of the leading scholastic Catholic thinker, he synthesized Aristotle and Plato together. And then it became a major corpus of the classical legal tradition. So the Catholics have been involved. They've been discussing this. They've adopted the notions, but they're not the only ones. And then the roots ties back to almost 2,000 years of legal practice, of legal reasoning. And if you believe in concepts like objective morality, of the common good and the true nature of law, there are no reason why you would not agree with common good constitutionalism.
We've got to go to break, but we will be right back.